Alright, this is part 2 of 13 of what's titled The British Legal System of Mixed Common and Roman Law Has Been Used to Enslave Us, USA. Presented in 13 parts, presented and edited by Eldon G. Warman. And then he has a little poster. Have you been hornswoggled? He's got a good website, and this is about our laws as relates to, well, it gets into a bit of the history of our laws. So the first part was pretty long. This one's not as long. Can't get the whole page in here. Okay, this is Building the Case, Part 2 of the British System. Okay, and it says, the first step in building any case which has a chance of winning is to analyze the problem. A common pattern for doing this is to recognize a problem that needs answering, analyze the problem by first stating it, reach a satisfactory judgment, and then defend our judgment. In preparing our case, our legal research will be determined entirely by the facts of the case, for without facts the law is meaningless. In marshalling our facts, we need to keep a few guiding principles in mind so we aren't led astray. We must discount preconceptions, postpone judgments, and we must observe for a purpose, know why we are observing, and stick to relevant facts about the case. The answers must be based on evidence, premises, and inferences. Okay, this is the common law. I can't get this right. Okay, let's explore the common law in depth and its embodiment in our Constitution. Probably one of the best ways of explaining what this common law is to explain what it is not, to compare it to its antithesis. There are fundamentally two competing systems of a man-made law in the world that are in constant ideological conflict against each other. One is the common law and the other is the civil law, or Roman civil law. For example, the Magna Carta 1215 used the antithesis method. Most articles are statements of normal practices in Roman law, with a thou shalt not added. A brief study of the philosophical background is presented in order to grasp the significance of the difference in the two systems. A triunity of God, or supreme being, concepts composed of, I'm sorry, I didn't read that right. It's okay. A brief study of the philosophical background is presented in order to grasp the significance of the difference in the two systems, period. A triunity of God, and then in parentheses, or supreme being, concepts composed of 1. God is the thing, the God out there, God within, God indwelling each individual, and within God, the person being a part of God, a cell in the body of God, etc., are the basic building blocks of religious understanding, the basic elements of man's religious and religious institutions, or religions and religious institutions. A balanced triunity, regardless of concept quality, would make for a harmonious religious and social structure. Some of the North American Indian tribes achieved such reasonably balanced plateau in their culture. However, some socially dominating cultures, such as Judaism, are dominated by number 1 and a bit of number 3. I'm sorry. The prior sentence about God is 1, God is, the God out there. Number 2, God within, God indwelling each individual, and number 3, within God, the person being a part of God, a cell in the body of God, etc. Okay, so Okay, so however, some socially dominating cultures such as Judaism are dominated by number 1 and a bit of number 3. Buddhism calls mostly on number 3 with some number 2. Consider where one would place communism, oligarchic dominance, American republicanism, the resonance. One can find these concepts ruling ancient civilizations and extending into the very roots of our current concept of statehood. The ancient Greek city-states developed in two and opposing directions because their philosophical thought gave some the God is concept in isolation to the other two concepts, while the other took the God within as their sole concept. One was oligarchic, the other was republican. Aristotle was a spokesman of the first, Plato of the second. The first leads to the final conclusion that man is an evolved animal, and as such must be controlled by a divinely appointed chosen few. This thread of belief structure comes down to our current era. One of the strongest of such belief structures resides within the current humanist mindset. The universe is, supposedly, deteriorating and returning to basic elements. So too would man revert to lower forms of animalism, if left to his own, without divinely appointed leaders, the oligarchs, the captain of the ship. The cult of Mother Earth, environmentalism, falls into this school of thought. The Republican God within society believes in the world and responsible nature of the individual. In a true republic, representatives are appointed and given responsibility for the public good as servants. Democracy is an oligarch mechanism to appease those people who by nature really are Republican. A democracy allows the people to choose their leaders, their slave masters. The oligarchs manipulate the economic and social structures so as to create a turmoil to keep their subjects constantly striving for the basic human institutions: self-maintenance, self-perpetuation, and self-gratification, and never allow these to reach a point where Republican thought, creativity, and altruism may become established. Excuse me. Okay, so with this background, you might better understand the difference between the oligarchic maritime law and the Republican enhancing Saxon common law. The oligarch entrepreneur's overthrow of ancient Israel's republican form of government is recorded in 1 Samuel chapter 8. Some worthwhile reading. That was 1 Samuel chapter 8. Okay, to consider the value of the God within concept to society, study the effect of the result of the Council of Florence, 1439, called by the Pope of the Roman Church of that time, at which the doctrine of the filioque, Christ indwelling, was established. Actually, it was a revival of the teaching of St. Augustine and Philo of Alexandria. The anti-Philo intrigues surrounding the Nicene Council and its resulting Nicene Creed is a study in itself regarding the imposition of oligarchy and its accompanying Roman dictators' type of rule over the Church. Even though it was not accepted by the Eastern, Byzantine, Rite, and the Jesuits, it resulted in the Renaissance, the Age of Reason, great artistic expression, and the Republican movements in Europe and America. J. Reuben Clark, a former U.S. Undersecretary of State and Ambassador to Mexico, succinctly stated the principles and applications of these two systems of law when he wrote, briefly and stated in general terms, the basic concept of these two systems was as opposite as the poles. In the civil law, the source of all law is the personal ruler, whether king or emperor. He is sovereign. In the common law, certainly as developed in America, the source of all law is the people. They as a whole are sovereign. During the centuries, these two systems have had an almost deadly rivalry for the control of society. The civil law and its fundamental concepts being the instruments through which ambitious men of genius and selfishness have set up and maintained despotisms. The common law, with its basic principles, being the instrument through which men of equal genius, but with love of mankind burning in their souls, have established and preserved liberty and free institutions. The Constitution of the United States embodies the loftiest concepts yet framed of this exalted concept. Thus, our heritage of freedom is a direct and proximate result of the common law, deriving its authority solely from the usages and customs of immemorial antiquity. The common law is the legal embodiment of practical common sense, and its guiding star has always been the rule of right and wrong, the golden rule. The common law is embodied in the U.S. Constitution for the protection and security of persons and property is substantive common law. Substantive right, a right as of life, liberty, property, or reputation, held to exist for its own sake and to constitute part of the normal legal order of society. The intention of the Founding Fathers being the assurance of access to this law by the people. Evidence will be further presented to show how other parts of the U.S. Constitution, dealing with totally different jurisdictions of admiralty and maritime law, had been used to subvert the people into or under this jurisdiction and bar access to the substantive common law. The basic element of the substantive common law is you, the individual man, male, female. In this jurisdiction, you are the sovereign and the captain of your own ship. The restoration of that exalted concept and access to the law by which men have established liberty and free institutions is the object of this brief. Okay, that's end part 2. And there's 13 other parts, but they're actually going back to the first page. At the top of this, it says, any guess as to which flag is the true flag of the people of the United States of America? And it gives the answer, probably not quick. And then, there was something in here I wanted to share. Well, treason. Learn the facts about the Vatican's and British Crown's continued claimed ownership of the USA and their continued collection of tribute from Americans through the Pope's Holy Roman Empire. And then there's also a lot of links. So, there's a lot of good information in here. So, alright. I don't know if I'm going to be able to read all 13 parts. Maybe somebody would like to join me and read some of them. I'm going to try to put them all in order. So, there you go. Today is the 16th. Okay.